The courtroom was silent. Not the polite kind of silence. Not the respectful kind. This was the kind that presses against your chest and makes it hard to breathe. The kind where even the air seems to stop moving. And then the voice broke. Not shouted. Not screamed. Broken. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. What happens when the person everyone expects to grieve becomes the center of a devastating accusation? That's the question hanging over this courtroom. That's the question pulling millions of people back to this case. And that's the question no one was prepared to hear spoken out loud. Because just moments earlier, this trial had followed a familiar script. Prosecutors, defense, evidence, timelines. A tragedy everyone thought they understood. Until one sentence shattered the entire story. And suddenly, the case wasn't just about who was arrested. It was about who was being accused. Let's rewind. This story begins the way so many true crime sagas do, with headlines that hit hard and fast. 2 elderly victims, a luxury estate, a family torn apart in a single night. The public consumed every detail as if the facts alone could explain the unexplainable. But what if the facts were only the surface? What if the truth lived somewhere deeper, messier, and far more uncomfortable? Ask yourself this as we begin. When a family collapses under pressure, does the truth come out? Or does something else rise to the surface instead? The tragedy at the center of this case shocked people not just because of its violence, but because of where it happened. A sprawling, multi-million-dollar estate. The kind of place associated with safety, success, and carefully curated appearances. The kind of home people assume is immune to chaos. It wasn't. Inside those gates lived a family with a long history, complicated relationships, and tensions that outsiders could never fully see. To the world, they were accomplished, stable, respected. Behind closed doors? That's what the courtroom is trying to untangle now. The public was first told that the discovery was made by a family member in the early hours after the incident. Shock, panic, confusion. Police were called. The house was sealed. The story seemed tragically straightforward. A suspect was identified quickly. An arrest followed. Charges were filed. Case closed, right? Except it wasn't. Because as investigators worked backward through the hours before the tragedy, small cracks began to appear. Not enough to stop the arrest. Not enough to change the charges. But enough to make certain people uneasy. Why did some timelines feel rushed? Why did certain details surface late? Why did family statements subtly change? At first, those questions lived only in whispers. Online forums. Quiet conversations. The kind that rarely make it into official records. Until court. Until testimony. Until one voice, trembling under oath, shifted the direction of everything. Picture the scene. The courtroom is packed. Cameras aren't allowed inside, but everyone knows what's at stake. Journalists lean forward. Attorneys sit rigid. Family members avoid eye contact. And then comes the moment no one planned for. A question is asked. Simple on the surface. Routine, even. But the answer doesn't follow the expected path. Instead, it veers. The witness pauses. Swallows. Hands shake. And then comes the claim. Not proven. Not supported. Not yet examined. But spoken. An accusation that lands like a dropped glass in a quiet room. Suddenly, the narrative fractures. The person on trial isn't just defending against charges anymore. He's redirecting attention, shifting focus, pointing somewhere no one was ready to look, toward someone seated just feet away, toward someone whose role had always been framed as secondary, peripheral, emotional, but not central. Until now. Ask yourself, when someone makes a claim like that in open court, what are they risking? Credibility, strategy, everything. So why say it? That's the question prosecutors asked themselves in real time. That's the question jurors exchanged glances over. That's the question echoing across social media now. Because accusations don't exist in a vacuum. They carry weight, consequences, collateral damage. And this one cut deep. The courtroom reacted instantly. Gasps, murmurs. A sharp instruction from the judge. The kind of chaos that rarely appears in legal dramas because real life doesn't usually allow it. Someone broke down. Not theatrically, not performatively. Collapsed. Hands to face. Shoulders shaking. A person visibly unraveling under the weight of being named. Is that guilt? Is that shock? Is that grief finally exploding after being contained too long? That's the danger of courtroom moments like this. Everyone sees the same thing, but no one sees it the same way. Some saw an emotional response consistent with devastation. Others saw something else entirely. And just like that, public opinion split. Because here's the uncomfortable truth. Emotion convinces people faster than evidence. And this case is saturated with emotion. Family dynamics complicate everything. Adoption, loyalty, resentment, love, rivalry, protection, silence. The things families don't say often matter more than what they do. This isn't just a legal battle. It's a psychological one. And the courtroom is the stage where every unresolved conflict is now being dragged into the light. The defense framed the accusation as long-buried tension finally surfacing, a narrative of manipulation, of secrets, of blame shifting. The prosecution saw something else. Desperation, deflection, a last-ditch attempt to fracture focus. Who's right? That's what this trial is supposed to decide. But trials don't happen in isolation. They happen under the gaze of millions. And the moment that accusation hit the record, the story escaped the courtroom. Headlines exploded. Social media dissected body language frame by frame. Old interviews were replayed. Family photos re-examined. Past comments suddenly felt loaded with new meaning. People asked questions they never asked before. Why did certain family members avoid interviews? Why did others speak too freely? Why did no one notice the cracks earlier? And perhaps the most unsettling question of all, what if everyone was wrong from the beginning? What if the person everyone focused on wasn't the full story? But be careful, because suspicion isn't truth, and accusations aren't verdicts. This case exists in a gray space where facts, feelings, and fear collide, and the courtroom is only just beginning to explore it. As opening statements concluded that day, one thing became clear. The trial the public thought it was watching no longer existed. This was no longer a straightforward prosecution. It was a battle over narrative, over credibility, over who the jury would believe when the facts stopped being clean and started becoming human. And somewhere in that mess sits the truth, tangled, contested, and painfully elusive. So as we move forward, remember this. Everything you're about to hear comes from testimony, claims, reactions, and contradictions. Nothing is settled, nothing is proven, and nothing should be taken at face value. Because in cases like this, the most dangerous assumption is thinking you already know the ending. And just as the courtroom tried to regain order, just as the judge prepared to move on, something else happened. Something small, almost invisible, that hinted this accusation was only the beginning. Because the next piece of testimony wouldn't just raise questions. It would expose a timeline that refused to behave. And that's when everything truly began to unravel. What happens when a courtroom thinks it's moving forward and instead slams into a wall? That's where we pick up. Right after the accusation. Right after the air went thin. Right after everyone realized the story they thought they were watching had just been ripped in half. The judge hadn't even finished speaking before the room reacted. A shuffle of feet. A sharp inhale from the gallery. Someone dropping a pen, the sound far louder than it should have been. The kind of noise that only happens when everyone is already on edge. And then silence again. But this time, it wasn't still. It was charged. Because now, there was something new sitting in the room. Something dangerous. An idea that couldn't be unheard. A name. Spoken under oath. Let's be clear about something right away. This wasn't part of the script. Not the prosecution's. Not the defense's. Not even the media's carefully pre-written headlines waiting outside the courthouse doors. This was a rupture. And ruptures don't politely ask permission. The judge did what judges do in moments like this. Calm voice. Firm tone. A reminder of procedure. An instruction to the jury to focus only on evidence, not emotion. But here's the truth no one likes to admit. You can tell a jury to disregard emotion. You can't make them unfeel it. The witness sat there, staring straight ahead now, jaw tight. Whatever had just been released into the room couldn't be pulled back. You could almost see the calculation happening in real time. Did I say too much? Or did I finally say what needed to be said? And across the aisle, the reaction was immediate. A chair scraped back. A hand flew to a mouth. A body folded forward like the floor had suddenly given way. This wasn't a quiet moment. This was collapse. Not the dramatic, performative kind people expect from courtroom TV. This was messy, uncontrolled, raw. Security shifted. Attorneys stood halfway, unsure whether to intervene. The judge called for order again, sharper this time. And still, the breakdown continued. Ask yourself something. If you were sitting there, watching this unfold, what would you think? Would you see shock, betrayal, or guilt? Because that's the problem with moments like this. They invite interpretation. And interpretation is where narratives are born. Within minutes, two competing stories began forming in the room. One side whispered, "This is what happens when an innocent person is blindsided by a lie." The other murmured, "This is what happens when a secret is dragged into the light." Which one feels more convincing? It depends entirely on what you already believe. The judge called a brief pause. Not a full recess. Just enough time for everyone to breathe. Just enough to stop the moment from turning into something uncontrollable. But even as the room reset, nothing really reset. Because now, every glance meant something. Every movement felt loaded. Every past action was being mentally replayed through a new lens. The prosecution huddled. Heads close. Voices low. You could see frustration flicker across faces trained to mask it. This wasn't just a curveball. It was a grenade rolled into the middle of their timeline. The defense, meanwhile, looked almost still. Not relieved. Not triumphant. Focused. As if they'd just watched a door open that they hadn't known for sure would ever unlock. And the jury? They watched everything. Because juries don't just listen to words. They read rooms. They read people. They notice who avoids eye contact. Who leans forward. Who stiffens when a name is mentioned. And right now, the room was screaming. When proceedings resumed, the questions shifted. Not dramatically, not obviously, but subtly. That's how skilled attorneys do it. They don't chase the explosion. They circle the smoke. The witness was asked to clarify, to explain context, to walk back through the statement carefully. And this is where things got even stranger. Because the more they explained, the less clear it became. Timelines overlapped in odd ways. Events were remembered differently depending on who was asked. Small details, a phone call, a door left open, a conversation no one thought mattered, suddenly felt enormous. Have you ever noticed how memory changes under pressure? How certainty fades the moment it's challenged? That's what the courtroom was watching now. A human being trying to navigate recollection while knowing every word could change everything. And then came the questions about motive. Careful questions. Neutral questions. Questions framed as hypothetical. But motive is a dangerous thing to introduce when you don't yet have proof. Because motive invites story. And story invites belief. The defense leaned into that. Slowly, methodically. They didn't accuse again. They didn't repeat the name. They didn't need to. They asked about relationships. About arguments. About things said in anger years earlier that everyone had laughed off at the time. Isn't it funny how jokes stop being jokes once something terrible happens? Suddenly, old moments felt heavy, loaded, predictive. The prosecution objected. More than once. Sustained. Overruled. Sustained again. The judge walked a careful line, allowing exploration without letting the trial dissolve into speculation. But here's the problem. Speculation had already escaped. Outside the courtroom, reporters were refreshing feeds. Producers were rewriting chants. Social media was doing what it does best, filling in blanks with certainty. And inside the courtroom, everyone could feel it. This case was no longer contained. Then came the moment that truly froze the room. A single question. Simple. Almost harmless. Can you tell the court where everyone was in the hour before the incident? The witness hesitated. Not long. Just long enough. And hesitation, in court, is loud. They answered. Slowly. Carefully. One person accounted for. Another uncertain. Someone asleep. Someone assumed to be elsewhere. Assumed. That word hung in the air. Assumptions are dangerous in criminal cases. Because assumptions are where doubt lives. And doubt, once planted, grows fast. The defense followed up. Again, gently. How do you know? Another pause. Another shift. I don't. I just believed. Believed. Not saw. Not confirmed. Believed. That was it. That was the crack. Because belief is not evidence. And suddenly, the timeline everyone thought was solid looked a lot more flexible. The prosecution moved quickly to regain ground. They redirected. Anchored back to physical evidence. Forensic conclusions. Established facts. But something had changed. The jury wasn't just listening anymore. They were weighing. And weighing is where verdicts are born. As the session drew to a close, the judge announced a longer recess. the kind that signals a significant moment has passed. People stood slowly. Conversations erupted in whispers. Security tightened. And in the middle of it all, the person at the center of the accusation was escorted out, face unreadable, shoulders squared, eyes fixed ahead. No tears, no words, just silence. Is that strength? Or control? Or something else entirely? Because the truth is, composure can mean anything. And so can collapse. That's what makes this so unsettling. There are no clear villains yet. No clear heroes. Just people reacting to pressure in different ways. And that's exactly why this case has become so consuming. Because it forces an uncomfortable question onto everyone watching. When everything falls apart, who do you believe? The person who speaks? Or the person who breaks? As the courtroom emptied and the doors closed behind the jury, one thing was certain. This wasn't a one-day shock. This accusation wasn't going to fade quietly into the transcript. It was going to be examined, challenged, picked apart. And in the process, it was going to expose something far more dangerous than blame. A timeline that didn't agree with itself. Because the next witness wouldn't talk about emotion. They wouldn't talk about belief. They would talk about time. And once time entered the conversation, nothing would stay simple again. What happens when the same family tells two completely different stories, and both sound believable? That's where the courtroom landed next. Not on bloodstains, not on weapons, not even on motive, on memory, on relationships, on the way people remember the same moments differently depending on where they stood when those moments happened. Because after the shock of the accusation settled into something heavier, something quieter, the trial did what trials always do when chaos threatens to take over. It slowed down. And slowing down can be more dangerous than drama. The next witness took the stand with none of the fireworks from the day before. No trembling voice. No collapse. No audible gasps when they spoke. Just calm. Measured. Almost rehearsed. And that calm alone made people uneasy. Have you ever noticed how silence can be louder than emotion? Because this witness didn't bring tears into the room. They brought structure. They spoke about the family as if laying out a map. Who lived where? Who spoke to whom? Who stopped talking years ago? Who always showed up for holidays? Who always found excuses not to? And slowly, subtly, two parallel versions of the same family began to emerge. In one version, everything was functional. Maybe strained at times, but manageable. Arguments came and went. Hurt feelings faded. Life moved forward. In the other version, nothing was resolved. Tension lingered. Old resentments hardened. Small slights accumulated like unpaid debts. Same house. Same people. Completely different emotional realities. Which one is real? The defense leaned into this divide immediately. They asked about patterns. Long-term dynamics. Who felt excluded? Who felt controlled? Who felt overlooked? Not accusations. Just questions. And each answer widened the gap. The prosecution, sensing where this was going, tried to pull the story back toward facts, toward events, toward the night itself. But the witness kept drifting into context. And context is dangerous because it makes everything feel intentional. The witness spoke about arguments that had never made headlines, about conversations that ended abruptly, about moments that, at the time, seemed unimportant. Until now. Now, every memory felt loaded. Every pause felt strategic. And every contradiction felt like it mattered more than it probably should. Let's pause here and ask something uncomfortable. When families fall apart, does anyone really know the whole story? Or do they only know their version of it? Because the courtroom wasn't hearing facts in isolation anymore. It was hearing perspectives. And perspectives don't line up neatly. The witness described one person as emotionally volatile, another as withdrawn, someone else as controlling but well-meaning. None of it illegal, none of it provable, all of it influential. The defense followed with a simple question. Did everyone feel safe in that house? The witness hesitated, just a fraction of a second. But by now, the jury knew what hesitation sounded like. I think so, they said. Think. Not know. Think. That word again. Belief. Assumption. Interpretation. It was becoming a theme. The prosecution objected to relevance. The judge, because the next line of questioning went somewhere no one expected. Money. Not wealth. Not inheritance. But control. Who made decisions? Who had access? Who felt dependent? Who felt trapped? This wasn't about greed. Not explicitly. It was about power. And power dynamics inside families can be invisible until they're not. The witness spoke carefully, clearly aware of the weight every word carried. They didn't accuse. They didn't imply guilt. They just described dynamics. But the room felt it. Because suddenly, the accusation from the previous day didn't sound as random anymore. It sounded contextual. The prosecution moved to redirect, pushing back against the idea that tension equals violence, that difficult relationships equal criminal intent. And they were right. They reminded the jury that many families are messy, many are complicated, many argue without anyone getting hurt. And that's true. But here's the problem. This case isn't about many families. It's about this one. And this one ended in tragedy. The jury watched as two legal teams painted two incompatible portraits using the same people. In one, the accused was desperate, cornered, and looking for someone else to blame. In the other, the accused was exposing something long buried, something everyone else had ignored because it was uncomfortable. Which portrait do you trust? The witness was excused, but the damage, or the clarity, was already done. Because now the jury had to hold two stories in their minds at the same time. And humans are not good at that. We crave coherence. We want one truth. But this trial was offering many. Outside the courtroom, analysis exploded. Some commentators focused on the witness's calm as credibility. Others saw it as distance. Some pointed to the emotional breakdown from the day before as proof of innocence. Others saw it as something else entirely. And everyone, absolutely everyone, started revisiting old footage, old interviews, old photographs. Moments that once seemed benign now felt ominous. Isn't it strange how context rewrites memory? A smile can look forced. Silence can look calculated. Grief can look suspicious. That's the danger of watching a story unfold in real time. We think we're seeing truth when we're really seeing interpretation layered on interpretation. Back in the courtroom, the next phase of testimony pushed even deeper. Another family-adjacent witness. Someone close enough to observe, distant enough to claim objectivity. They spoke about routine, daily habits, who woke early, who stayed up late, who checked in, who withdrew. And once again, two stories emerged. One of predictability, one of isolation. The defense highlighted inconsistencies between this witness's account and earlier testimony. Not dramatic contradictions, subtle ones. Time estimates that didn't match, descriptions that felt softened, memories that changed depending on how the question was phrased. The prosecution countered with a crucial point. Memory isn't static. Stress distorts recall. Trauma reshapes timelines. And that's true too. So where does that leave us? With a courtroom full of people trying to reconstruct reality using fragments filtered through emotion. And that's before the physical evidence even enters the picture. As the day wore on, fatigue set in. The jury shifted in their seats. The judge checked the clock more frequently. But something else was happening beneath the surface. The accusation was no longer the center of attention. The family dynamic was. Because if the family itself couldn't agree on what life inside that house felt like, how could anyone be sure what happened inside it on one specific night? That question hung heavy as proceedings paused again. The attorneys packed up. Witnesses stepped down. Jurors filed out quietly, deep in thought. And behind the scenes, legal teams recalibrated. Because the next phase of this trial wouldn't be about feelings. It would be about structure, about timelines, about whether two stories could exist in the same hour. And that's where things get dangerous. Because once you introduce time into a fractured narrative, someone's version stops working. As the court prepared to reconvene the following morning, a new witness was scheduled. Not emotional, not relational, technical, precise. Someone who deals in minutes, not memories. And if their testimony didn't align with one of these stories, then one of them was about to collapse completely. Because time doesn't care about belief. It only cares about where you were and when. And when that witness took the stand, the courtroom would finally learn whether both stories could survive the clock. What if the one thing everyone trusted was the one thing lying to them? That's the question the courtroom walked into that morning, whether they realized it or not. Because emotions can be debated, motives can be argued, relationships can be interpreted 1,000 different ways. But time is supposed to be neutral, cold, unemotional, and unforgiving. The witness took the stand without ceremony. No visible nerves. No dramatic pauses. No emotional preamble. Just a professional posture and a stack of notes arranged with almost unsettling precision. This wasn't someone here to tell a story. This was someone here to measure one. And the moment they were sworn in, the tone shifted. You could feel it. This was no longer about who felt what. It was about who was where and when. The defense opened with a simple framing question. Can you explain your role in reviewing the timeline of events? The answer was straightforward, methodical, boring even. And that's exactly what made it dangerous. Because boring testimony doesn't distract. It doesn't entertain. It forces people to listen. The witness explained how timelines are reconstructed, how data points are collected, how assumptions are flagged, how gaps are identified, not filled, identified. That distinction mattered. Because what the jury was about to hear wasn't a story stitched together to make sense. It was a structure with holes. The first hour came up immediately. The hour everyone had been talking about. The hour before everything went wrong. Phones, movements, entry points, exit points, light usage, environmental details. Nothing graphic, nothing sensational, just sequence. And that's when the first problem appeared. The witness explained that several key moments overlapped in ways they shouldn't have. Not dramatically, subtly. One person was said to be in two places too close together for comfort. Another's activity window was based entirely on assumption rather than confirmation. A third timeline relied on a device interaction that might not have occurred when everyone believed it did. The defense asked a careful follow-up. Are these discrepancies unusual? The witness paused. Not at first, they said, because early reconstructions are often messy. People guess. Memory fills in blanks. Narratives form before facts solidify. But then they added something that made the room lean forward. What is unusual is that these discrepancies were never corrected. Never corrected. That's when the courtroom froze again. Because that wasn't an emotional statement. That was a procedural one. It suggested that the story had been allowed to harden before it was fully examined. The prosecution objected to implication. The judge overruled, allowing clarification. The witness explained that in their experience, timelines evolve. They tighten. They change as new data emerges. But here, certain assumptions remained untouched. Why? That was the question hanging in the air. The witness didn't answer it directly. They didn't need to. They just showed the jury where the assumptions lived. And once you see an assumption, you can't unsee it. The defense zeroed in on one specific segment of time. A narrow window. Minutes, not hours. The witness laid it out with care. At this point, according to statements, one person was asleep. Another was awake, but not moving. A third was believed to be elsewhere. Believed. Again, that word. The defense asked the question everyone had been waiting for. Which of these positions is confirmed by independent data? The answer came quickly. Only one. The courtroom shifted. One position. Out of several. Confirmed. The rest? Inferred. Estimated. Assumed. The prosecution stepped in immediately, emphasizing that lack of data does not equal wrongdoing. That absence of confirmation does not imply presence elsewhere. And they were right. But here's the problem. This wasn't about guilt yet. It was about reliability. And reliability had just taken a hit. The witness moved on to the next inconsistency. A device interaction that occurred later than expected. A delay that didn't match the initial narrative. Not impossible, but inconvenient. The defense asked how such a delay could happen. The witness explained possibilities. Background processes. Human error. Device lag. Then they explained probabilities. And probabilities, unlike possibilities, have weight. The prosecution countered with alternative explanations. Reasonable ones. Logical ones. But even reasonable explanations don't erase doubt. They just compete with it. And now the jury had options. Too many options. The judge called for a short break. Not because of disruption, but because everyone needed a moment to recalibrate. During that break, you could see it on faces. The mental math. The quiet recalculation. Because once time stops behaving, everything else becomes suspect. When proceedings resumed, the witness addressed the final piece of the hour. A moment everyone thought they understood. A movement through the house. Short, unremarkable, but essential. The timeline placed this movement at a specific minute. The witness explained that the placement was based on a chain of assumptions stacked on each other. If this happened, then that must have happened. If that happened, then this must have followed. It was logical. But logic built on assumptions is fragile. The defense asked the question that landed hardest. If one assumption fails, what happens to the timeline? The witness didn't hesitate. It collapses. Not shifts. Not adjusts. Collapses. Because timelines aren't stories. They're structures. And weak foundations don't hold weight. The prosecution pushed back hard here, emphasizing corroborating testimony, the number of people who agreed on the general flow of events. And again, that argument made sense, until the witness clarified something crucial. Agreement does not equal accuracy. People often align their memories unconsciously, especially after talking to each other, especially after media coverage, especially after trauma. Memory is social. That statement hit harder than any accusation, because it suggested something unsettling, that even honest people could be reinforcing a flawed narrative without realizing it. The judge allowed the line of questioning to continue, but with caution, and the witness delivered the final blow of the morning. They explained that when the timeline was reconstructed without assumptions, using only confirmed data, a different picture emerged. Not a clear one, but a different one. A window opened. A window no one had been looking at. And inside that window, the certainty disappeared. The defense didn't ask for conclusions. They didn't need to. The damage was done. Because now the jury knew something critical. The timeline everyone trusted was not fixed. It was flexible. And flexibility in a criminal case is terrifying. As the witness stepped down, the courtroom buzzed with quiet tension. No gasps this time. No breakdowns. Just the slow realization that the foundation of the case had shifted. Outside, analysts scrambled to reinterpret everything they thought they knew. Inside, the legal teams prepared for war. Because the next step was inevitable. If the timeline wasn't stable, then alibis weren't either. And if alibis weren't solid, then the focus would narrow. Painfully. Because once time starts pointing fingers, it doesn't point at everyone. It points at someone. What if the thing everyone thought they understood was the thing misleading them the most? That was the question lingering in the courtroom as the next phase began. Not about minutes. Not about devices. Not about where someone stood at a specific second. But about grief. Because once the timeline cracked, attention drifted somewhere more human. More subjective. More dangerous. How people react when everything collapses. And whether those reactions can be trusted. The courtroom felt different that morning. Less tense in a sharp, electric way. More heavy. Weighted. Like everyone had woken up carrying the same unresolved thought. If the timeline isn't solid, then what are we actually judging? The next witness was introduced quietly. No fanfare. No anticipation from the press. But the moment they took the stand, eyes followed them. This witness wasn't there to talk about evidence. They were there to talk about behavior. And behavior, in cases like this, has a way of hijacking logic. The questioning began gently. Background. Relationship to the family. Frequency of contact. Routine interactions. Then the shift. How did each person respond in the days following the tragedy? That's when the room leaned in. Because this is where opinions form. The witness described scenes that sounded familiar to anyone who's ever experienced loss. Shock. Disbelief. Emotional swings. Silence punctuated by sudden tears. But they didn't stop there. They described differences. One person withdrew completely. Stopped answering messages. Avoided eye contact. Moved mechanically, as if following instructions rather than feelings. Another sought constant reassurance. Asked the same questions repeatedly. Wanted to talk. Wanted to be heard. A third oscillated. Calm one moment. Overwhelmed the next. None of this was criminal. All of it was interpreted. And interpretation is where danger creeps in. The defense allowed the descriptions to sit for a moment before asking the question they knew would land. Did any of these reactions strike you as unusual? The witness hesitated. Just long enough. Unusual compared to what? They finally said. That answer mattered. Because grief doesn't have a template. There is no correct way to fall apart. Some people cry loudly. Others shut down. Some clean obsessively. Others can't get out of bed. So when we judge grief, what are we really judging? The prosecution seized on this, reinforcing that trauma manifests differently in everyone. That shock can numb emotion. That dissociation can look like indifference from the outside. And they were right. But the defense wasn't arguing guilt. They were arguing perception. They asked about specific moments. Who spoke publicly? Who stayed silent? Who appeared composed when cameras were present? Not to accuse. To contrast, the witness described a moment that had already circulated online. A brief appearance, a few words spoken, a steady tone. Some people saw strength in that moment. Others saw something colder. And that split followed the case everywhere. Because the public loves to believe grief should look a certain way. Red eyes, cracked voices, visible pain. But real grief doesn't perform on cue. The defense asked the question quietly. Did you interpret composure as absence of grief? The witness answered honestly. At first, yes. At first. That mattered. Because first impressions are powerful. And in high-profile cases, first impressions don't just stick, they spread. The courtroom then heard from an expert. Not about evidence. About trauma response. They spoke calmly, clinically, almost detached. They explained how shock can suppress visible emotion. How some people enter survival mode. How control can feel safer than vulnerability. They also explained something else. That grief can trigger unexpected behaviors. Anger. Defensiveness. Attempts to control narrative. Not because of guilt, but because of fear. Fear of loss compounding loss. Fear of being misunderstood. Fear of losing the last pieces of stability. The jury listened closely. Because suddenly, behaviors that once felt suspicious had alternate explanations. But alternate explanations don't erase doubt. They multiply it. The defense asked a question that cut through the theory. Is it possible for two people experiencing the same loss to react in completely opposite ways? Yes, the expert said. It's common. Then came the follow-up. Is it also possible for those differences to create misunderstanding? Absolutely. That answer landed heavier than expected. Because misunderstanding doesn't require malice. It requires distance. And this family, by every account, had distance long before tragedy struck. The prosecution redirected, emphasizing that behavioral interpretation should never outweigh physical evidence. That how someone looks is not proof of what they did. Again, they were right. But the jury wasn't weighing proof yet. They were weighing people. The witness stepped down, and the courtroom shifted again. Because now, everyone watching had to confront something uncomfortable. They had formed opinions based on reactions, based on tone, based on body language. And those opinions might not mean what they thought they did. Outside the courtroom, debate intensified. Commentators argued about whether composure was strength or calculation, whether collapse was innocence or shock, whether public displays of grief should matter at all. And inside the courtroom, the judge reminded the jury of something crucial. Behavior is not evidence, but perception influences belief, and belief influences interpretation. That reminder came just in time. Because the next witness would blur those lines even further. They weren't an expert. They weren't a family member. They were someone who observed everything quietly. Someone who noticed patterns without emotional attachment. Someone whose testimony would force the jury to confront how much weight they'd placed on appearances. This witness spoke about small moments. Who spoke first when bad news arrived. Who asked procedural questions. Who wanted details. Who avoided them. None of it illegal. None of it conclusive. But all of it suggestive. The defense highlighted one moment in particular. A decision made quickly. A choice that prioritized order over emotion. Again, some saw that as control. Others saw it as survival. And that's the heart of this chapter. Because grief isn't just pain. It's instinct. And instincts don't all point in the same direction. As the day drew to a close, the courtroom felt unsettled. Not because something explosive had happened, but because certainty had quietly eroded. The jury wasn't being asked to decide who cried the most. They were being asked to decide whether behavior could mislead. And that's a terrifying place to be. Because if grief can look like anything, then what else might we be misreading? As the judge adjourned for the day, one thought hung heavy in the air. If emotion can't be trusted, then the next phase of this trial would shift somewhere colder, somewhere harder to explain away. Because the next witness wouldn't talk about feelings. They wouldn't talk about memory. They would talk about decisions. And one decision, made in a single moment, was about to reframe everything. What if the most dangerous statement in a trial isn't the one rehearsed for weeks, but the one that slips out when control finally cracks? But this time it wasn't shock. It was recognition. Because this wasn't the first accusation. But it was different. This one wasn't framed as a claim of guilt. It was framed as fear. Fear expressed before anything happened. Fear that now looked prophetic. The judge raised a hand immediately, called for clarification, for context, for restraint. But the damage was done, because the jury had just heard something new, a suggestion that fear existed before tragedy. And fear before an event carries more weight than fear after. The prosecution objected. Strongly. Immediately. They argued relevance. Hearsay. Speculation. Prejudicial impact. And they had a point. Fear is subjective. People fear many things that never happen. But the defense didn't argue that fear proved anything. They argued that fear revealed something. A state of mind. A tension beneath the surface. The witness tried to walk it back. Clarify. Explain that the fear wasn't specific. That it wasn't directed. That it could have meant anything. But walking something back doesn't erase the moment it was said. Because now, the courtroom had context it didn't have before. Context that reframed the earlier accusation. What once sounded spontaneous now felt connected. The prosecution redirected quickly, trying to re-establish control. They asked about other fears, other anxieties expressed by other family members. And the witness admitted there were many. Everyone was on edge. Everyone was stressed, which made sense. But here's the problem. Not all fears are equal, and the jury could feel that difference. The defense asked one final question before sitting down. Was that fear taken seriously at the time? The witness answered honestly. No. That word hit harder than expected. Because now, the story had a new layer. A warning. Ignored. Or dismissed. Or misunderstood. And once again, interpretation flooded in. Was it paranoia? Was it intuition? Was it something else entirely? The judge called for a brief recess. Not because of disorder, but because the courtroom needed to breathe. And during that break, something fascinating happened. The energy shifted. This wasn't about accusations anymore. It was about anticipation. Because the jury wasn't thinking about what had been proven. They were thinking about what hadn't been explored. Why fear existed. Why it was dismissed. And why it resurfaced now. When court resumed, the atmosphere was tighter, controlled, as if everyone had silently agreed to be more careful. The prosecution called their next witness. Someone expected to stabilize things. Someone procedural. Someone factual. But even facts felt unstable now. This witness spoke about decisions made immediately after the incident. Who called whom? Who contacted authorities? Who handled logistics? Routine things. Necessary things. And then came the detail that no one had focused on before. A decision made quickly, decisively, without consultation. The witness described it as practical, efficient, but the defense saw an opening. They asked why that decision was made so fast. The witness shrugged. It just seemed obvious. Obvious. Another dangerous word. Because obviousness assumes consensus. And consensus hadn't existed anywhere else in this story. The defense pressed gently. Did everyone agree? The witness hesitated. No. That hesitation spoke volumes. Because disagreement implies conflict. And conflict, again, brings us back to motive. The prosecution intervened, redirecting away from implication. They emphasized that in emergencies, someone has to act. That speed doesn't equal secrecy. That efficiency doesn't equal intent. All reasonable. All logical. But the jury wasn't just absorbing logic anymore. They were assembling a mosaic. Piece by piece. Decision by decision. Reaction by reaction. And this piece didn't quite fit where it was supposed to. As the witness stepped down, the judge reminded everyone that speculation was not evidence. But reminders don't erase impressions. They just acknowledge them. As the day wound down, the courtroom buzzed quietly. No dramatic outbursts. No headlines yet. But something had shifted again. The accusation that once felt impulsive now had roots. Not proof. Roots. And roots grow. The judge announced adjournment for the day. But no one rushed out. People lingered, whispered, exchanged looks. Because the next witness on the schedule wasn't emotional, wasn't relational, wasn't even technical. They were procedural. Someone who could answer one very dangerous question. What happened after fear was expressed? But before everything fell apart. Because if fear existed beforehand, and if decisions were made quickly afterward, then the space in between mattered more than anyone realized. And that space was about to be illuminated. What really happens when the courtroom doors close? But the story keeps talking. That was the question hovering over everything as the trial slipped into recess. Because while judges call breaks to restore order, recesses don't pause reality. They amplify it. The moment the jury was escorted out and the courtroom doors swung shut, something invisible but powerful took over. Momentum. And momentum doesn't care about procedure. It feeds on whispers, on glances, on what people say when they think no one is listening. Inside the courtroom, the official record stopped. Outside it, the story exploded. Attorneys gathered in tight clusters, voices low but urgent, not arguing, recalibrating. You could tell by the way papers were shuffled without being read, by the way phones were checked more often than usual. This wasn't panic. This was strategy under pressure. Because the accusation that wasn't planned had done something irreversible. It had changed how every subsequent action would be interpreted, and everyone knew it. Family members were separated now, whether intentionally or not. Some sat alone, staring at nothing. Others leaned toward confidants, whispering fiercely, hands moving in sharp, restrained gestures. Security lingered closer than before, not because of danger, because of tension. And tension makes people unpredictable. Ask yourself something. When you hear a shocking claim in public, what do you do first? You look for confirmation. That's exactly what happened next. Phones lit up. Messages flew. Journalists didn't need quotes. They needed reactions. And reactions were everywhere. Some came in the form of silence. Others came in the form of a single phrase repeated to anyone who would listen. This is being taken out of context. Context. That word again. Context has become the shield of this trial. Because everyone agrees on one thing now. Without context, nothing makes sense. But here's the problem. Everyone's context is different. In one corner, sources close to one side described shock and betrayal. They spoke of disbelief, of being blindsided by an accusation they claim came out of nowhere. In another corner, quiet confirmations emerged. Not confirmations of guilt, confirmations of tension. People saying, "We always knew something was off," or "This didn't surprise us." Those statements didn't make headlines, but they spread. And sometimes, what spreads quietly is more dangerous than what spreads loudly. Inside the courthouse, legal teams watch this unfold in real time. Because trials don't just happen in courtrooms anymore. They happen on timelines, on comment threads, on panels and podcasts and reaction videos. And the jury, even if shielded, exists in the same world. They feel the pressure. They sense the gravity. The judge knew this. That's why the recess lasted longer than scheduled. Time wasn't just being given for rest. It was being used to cool something that had begun to burn. But heat doesn't disappear just because you step away from it. It settles. And during that settling, people talk. Someone close to the proceedings was overheard saying, "That wasn't supposed to come out like that." Another voice responded. But once it did, there was no going back. That exchange alone says everything. Because planned accusations are controlled, unplanned ones are raw. And raw statements carry a kind of credibility that polished arguments don't. But raw also means reckless. And recklessness has consequences. By the time court reconvened, the mood had changed again. Not dramatically, subtly, like the air after a storm that hasn't quite cleared. The judge entered with a different posture. More deliberate, more alert. Instructions were given. Carefully worded reminders about relevance, about speculation, about the weight of testimony. But here's what no instruction can undo. The jury had seen how people reacted when control slipped. And reactions reveal things evidence can't. The prosecution adjusted their approach immediately. They slowed down. They tightened questions. They avoided open-ended prompts. They were closing doors that had been flung wide open the day before. The defense noticed and smiled, not visibly, but strategically, because closing doors means something got through. The next witness was called, but before they even spoke, something unusual happened. The judge addressed the court directly. They referenced the previous day's testimony without repeating it. They emphasized the importance of patience, of withholding judgment, of understanding that trials unfold in phases. It was a warning, not to the jury, to everyone. Because once speculation takes over, trials become impossible to control, and speculation was everywhere. During questioning, the witness answered plainly, procedurally, nothing explosive. But then the defense asked something small, almost throwaway. "Were you present during the recess?" The witness nodded. "And did you observe any reactions?" The prosecution objected instantly. Sustained. But the damage was done. The jury knew what the defense was pointing toward. What happened off the record mattered. Because people are often more honest when they think the spotlight is off. That's why recesses are dangerous. They reveal instinct. Later that afternoon, reports began circulating. Not official, not sourced, but persistent. Claims of raised voices in hallways. Claims of someone leaving abruptly. Claims of someone else remaining unusually composed. Again, interpretation flooded in. Was abruptness guilt? Was composure calculation? Or were these just humans reacting to pressure? Here's the thing. Every interpretation says more about the interpreter than the subject. But juries are made of humans. And humans interpret. Inside the courtroom, the next testimony centered on communications after the incident. Who called whom? Who texted? Who stayed silent? Not content, timing. Timing again. Because timing is harder to explain away. The witness described a delay in response. Not long, but noticeable. The defense asked why. The witness shrugged. They didn't know. And that's what made it unsettling. Because silence after fear is louder than fear itself. The prosecution argued that shock can freeze communication. That trauma disrupts normal patterns. Again, reasonable. Again, plausible. But this trial had moved beyond plausibility. It was now about probability. Which explanation fits better? And worse, which explanation feels better? Because feeling has started to creep into logic. As the afternoon wore on, fatigue returned. But it wasn't the sleepy kind. It was the kind that makes people careless. And carelessness leads to leaks. By the time the judge called for adjournment, multiple outlets were already framing the recess as a turning point. Not because of what was proven, but because of what was revealed accidentally. The judge issued a rare warning before dismissing the court. A reminder that reactions outside testimony are not evidence. That interpretation without proof is dangerous. That fairness depends on restraint. But restraint is fragile when curiosity is burning. As people filed out, one quiet moment stood out. Two individuals crossed paths. No words, just a look. Long, unbroken, and charged with something impossible to define. Anger? Fear? Recognition? No one knows. But those who saw it said the same thing. That look wasn't new. It was familiar. As if something unspoken had been circulating long before the courtroom ever convened. And that's what made this recess different. It wasn't just a pause. It was a revelation. Not of facts. Of fractures. Because whatever the truth is in this case, one thing is now undeniable. This family wasn't just divided by tragedy. They were divided long before it. And the next witness would force the court to confront that division directly. Because the next testimony wouldn't come from observation. It would come from documentation. Something written. Something preserved. Something that couldn't change its story to match the room. And once those words entered the record, the whispers would stop matching. Because paper doesn't whisper. It testifies. What happens when a room full of speculation meets something that doesn't speculate back? That's the question that settled over the courtroom as the next witness was sworn in. No rustle of anticipation this time. No whispering cascade from the gallery. Just a stillness that felt deliberate. Because everyone knew what was coming. Something written. Something preserved. Something that wouldn't adjust its tone to the mood of the room. The witness didn't carry stacks of papers. No bulging folders. Just a slim file placed carefully on the stand, like it mattered where it landed. That alone was unsettling. The prosecution began with foundations. Who the witness was. Why they were here. How they came into possession of the document. Nothing dramatic. Just clarity. And then the question that shifted the air. Can you tell the court what this document is? The witness nodded. A contemporaneous record, they said. Created before the incident. Not altered afterward. Before. That word snapped everyone to attention. Because anything created before tragedy carries a different weight than anything written after it. Before doesn't know what's coming. Before doesn't try to protect itself. Before doesn't rewrite. The defense leaned back, watching carefully. The judge leaned forward. The jury stopped blinking. The witness explained how the document came to exist. Not in crisis. Not in panic. In routine. In a moment that, at the time, felt ordinary. A note. A message. A written reflection. Not a confession. Not an accusation. But a snapshot of thought. The prosecution asked permission to enter it into the record. Granted. And just like that, the room changed again. The witness read slowly. Carefully. Not theatrically. Not emotionally. That restraint mattered. Because what they were reading didn't need embellishment. It spoke in plain language. Concern, unease, a sense that something wasn't right. No names at first, just descriptions, patterns, behaviors that felt unsettling to the writer. The defense watched closely, waiting. The prosecution allowed the words to breathe. And then came the line that made several jurors look up at the same time. A sentence that didn't accuse, but warned. Not of violence, of volatility. The witness paused after reading it, as instructed. The courtroom sat with it, because this wasn't testimony shaped by hindsight. This was a voice from before, and voices from before are dangerous. The defense rose slowly. Was this document shared with anyone at the time? Yes, the witness answered. With whom? The witness named a person, not the accused, not the accuser, someone in between, someone who now sat very still in the courtroom. The defense asked the next question gently. Was any action taken? The witness shook their head. No. That word again. No. Ignored. Dismissed. Filed away. The defense didn't push further. They didn't need to, because the implication was already alive. The prosecution redirected quickly, asking about context, about stress levels, about whether the writer was prone to anxiety. The witness answered honestly. Yes, there had been stress. Yes, there had been tension. But then they added something unexpected. This wasn't written during an argument, they said. It wasn't reactive. It was reflective. Reflective. That distinction mattered. Because reactive writing is emotional. Reflective writing is observational. The jury absorbed that. The defense then asked the question that turned observation into something sharper. Does the document mention fear? The witness looked down at the page. Yes. A murmur rippled through the room before the judge silenced it. Fear again. Before. The defense asked the witness to read that portion. The words were simple. No dramatics. Just concern that someone might lose control. Not might hurt. Might lose control. And that phrase hung there. Because losing control doesn't imply intent. It implies instability. The prosecution objected to interpretation. Sustained. But the words were already heard. And words heard can't be unheard. The defense stepped back, letting the document do the work. Because the most effective evidence doesn't argue. It sits. The next phase of questioning shifted to authentication. Dates. Metadata. Verification that the document hadn't been edited. The witness confirmed. The document predated everything. No changes. No additions. No deletions. That locked it in time. And time, in this trial, had become the most dangerous witness of all. The prosecution attempted to neutralize the impact by contextualizing the writer's perspective, suggesting misinterpretation, suggesting exaggeration. Again, reasonable. But the jury wasn't deciding whether the document proved anything. They were deciding whether it mattered. And it did. Because it connected too many dots. Fear before the incident. Tension beneath the surface. Warnings that didn't make headlines. Warnings that weren't taken seriously. That pattern was starting to repeat. The witness was excused, but the document remained. Not physically, jurors don't get it yet. But mentally. It sat there, folded into their understanding of the case. The judge called for a brief pause. No one moved. Because something had just broken through the noise. Not certainty. Silence. The kind of silence that follows recognition. When court resumed, the defense surprised everyone by calling no one. They rested. Just like that. No flourish. No final jab. Because they didn't need one. They had introduced doubt in its most dangerous form. Pre-event concern. The prosecution, suddenly on the back foot, scrambled to reassert control. They called their next witness immediately. Someone expected to contextualize the document, to downplay it, to explain it away. This witness spoke about how families often document concerns that never materialize. How fear doesn't equal foresight. How many people write things that never come true. All true, all valid. But then the defense cross-examined. They asked one question. Can you point to anything in this document that was proven wrong? The witness hesitated. They couldn't, because the document didn't make claims. It made observations. And observations can't be disproven. They can only be reinterpreted. That's when the judge intervened, steering the court away from philosophical territory. But it was too late. The jury was already there. As the day wound down, the courtroom felt different again. Heavier. Not chaotic. Not volatile. Just burdened. Because now,